Hi Esmeralda. By way of introduction, I am Yasser Mohammed, a trained mediator and a trainee solicitor employed at Bodge, Lodge and Hassel Solicitors. I am fully aware of the issues and matters concerning you and your neighbour and aim to work alongside both parties to come to a satisfactory conclusion on the topic. The mediation process is essentially an informal way of achieving a satisfactory conclusion to a dispute, which often merely rises through misunderstanding. There is no legal obligation for you to adhere to the procedures, although you may choose to commit to yourself to the result. Hopefully you do come to the result. I would like to take this moment to explain or tell you why mediation may be more beneficial than taking the matter to court. Having taken the matter to court, there may be evidential problems, such as producing deeds and plans or other proofs. Also, it may cost you a lot more than mediation by taking the matter to court. Sometimes, some matters cost more than the actual value of the property or the disputed land itself. And on the matter of cost, I should also mention that this may incur a devaluating of your property, as upon selling it you will have to disclose any disputes or matters concerning neighbors, which may deter potential buyers. And also, I would like to mention how mediation is very beneficial for, or well, more beneficial to you than, is more beneficial for boundary disputes than taking it to court. First of all, both parties would retain control of the outcome. The mediator being me will be totally impartial, and being a speedy and cost-effective process is totally the contrary to taking it to court. This will also allow you to come to agreed terms that the courts may not. And what I mean by that, sometimes you find the courts do not rule in a satisfactory sense for either party, so both parties may not be happy with the outcome. Now, the procedure of mediation is as follows. There is the opening phase, where both parties will have the opportunity to submit their case in turn, so one will not interrupt the other as they are submitting their terms. This procedure will be confidential, and it is important that both you and Anakin understand that as a result of this procedure, anything mentioned within the procedure may not be used outside it. So certain things said or mentioned may not be used in court as evidence, as it's only applicable to mediation and it's highly confidential. Then we will move on to the exploration phase, which is sorry, which would then be both parties being taken to their own private rooms, where I will discuss the procedures and the proceedings to the mediation process and what has happened so far. Then, sorry, then we will move on to the negotiation phase. Here is where the parties will put forward their proposals for settlement and could possibly be a joint meeting depending on parties' interests. Finally, the settlement and closing phase will be initiated. By now, a settlement should have been reached, hopefully, whereby I will draw up a settlement agreement, or maybe one of your lawyers may do so. Lastly, there will be a joint meeting held to confirm the outcome whatever that may be. I must say that I'm already very impressed by your two's mutual willingness to come to a solution. But at the same time, it's not very surprising, since you have been neighbors for a very long time, and good neighbors at that. This morning, you were kind enough to explain your position and elaborate on your concerns. This afternoon, Anakin went over the matter of boundary dispute and the dogs and various other concerning issues. I have seen a thread of regret on both sides concerning the misunderstanding and the seemingly unaware breakdown of communication. Well, I say unaware because it wasn't so intentional, hopefully. I hope. That's why I am confident that we can reach a mutually acceptable resolution. The primary matter is dividing you is the issue of boundary fence. You feel that the narrow width of the driveway would hinder your ability to open and close the car door fully, and also allowing access. Your back problem would then make it even more so difficult to get in and out of your car. You have also expressed a concern, for Anakin playing music so loudly that it upsets you and in turn results in your dogs barking inconsistently. The barking has in turn upset Anakin. The matter of the curry, however, the smells seems to have become a reciprocal irritant to, to both of you and possibly resulting in the dogs soiling Anakin's garden. Sorry about that. I am happy to say, after a very constructive conversation with Anakin, I am now in the position of being able to discuss the draft resolution. This resolution will enable both of you to re-establish your mutual respect for each other and hopefully get back on the good terms you once were. Esmeralda, I understand that if the fence did not intrude on your driveway, or restrict the width of it, then you would not object. We get sorry about that once again. We may find it sorry, you may find it easier to arrive to a conclusion if the fence was not there. But the reason why I bring this up first, because I feel if we deal with the boundary of the fence first, meaning the key issue as it concerns your back and your well-being, having resolved this, it will be a lot more easier to resolve the other issues. Well, Anakin has accepted that your back problem is a cause for concern, so he has agreed to withdraw his proposal to erect a fence. Instead, there will be a clear white line indicating the sides of the driveways of both properties. I must stress that this line would not be a legally stipulating boundary to your properties, but rather a mutually accepted boundary, the space between the car parking. Further, Anakin has asked me to assure you that he will henceforth ensure that he closes the bin lids to stop the smell from escaping and causing a disturbance. In turn, he is asked to be reassured that the guests will not block his driveway, hindering his maneuvering capabilities and blocking his driveway. With the respect to the dogs, I appreciate that no one has seen the dogs fouling Anakin's garden, but and I accept that it is involuntary occurred. But Esmeralda has agreed to keep a closer eye on her dogs to prevent this from happening again. Now, here is a draft mediation agreement on the terms you have agreed upon. You being Miss Esmeralda Airwax and the other party being Anakin Skydiver. It represents a final resolution to the matter pertaining to the boundary issue and a mutually shared driveway, and the matter of guests parking there. The concerns of Mr. Anakin relating to Miss Esmeralda's dog have also been addressed. It is recognized that both parties have exemplary neighbors, and that any issue that they have given rise to may be a cause of mere misunderstanding, and the disputes can amicably be resolved. The issue of Mr. Anakin Skydiver erecting a fence along the mutually shared driveway is resolved. This fence will not now be erected, sorry. Instead, there will be a clear white line defining the two driveways. This is done out of concern of Miss Arax's back pains and her not being able to get in and out of her car by opening the door fully. Miss Arax will ensure that the guests do not obstruct the driveway or cause hindrance to Mr. Skydiver's parking space. Sorry. Both neighbors agree that lids will be fully closed. Sorry, to prevent the smell from causing a disturbance. Miss Arax asserts that she will endeavor to keep her dogs within her own boundaries and keep a close eye on them, so to prevent another mishap on your garden. Um, Anakin's garden happening again. Both parties agree and shall abide by this agreement, and I'm really grateful for both of you and your time, and hopefully you will never, sorry, not never, hopefully you will never come to another situation like this and you can live alongside each other happily.